Hi everyone, I'm Daniel Gold, attorney, eDiscovery consultant, and senior director for corporate accounts at Catalyst. And welcome to another episode of eDiscovery Gold Nuggets, where we deliver to you bite-sized nuggets of incredibly valuable information that you need to become more productive and successful as legal professionals. In today's eDiscovery Gold Nuggets video, we are going to unravel and solve the litigation hold problem. Well, what exactly is that problem, you ask? As we all know, there's lots of risks associated for legal operations professionals and in-house counsel when it comes to the litigation hold. For instance, successfully avoiding the risk of advertent or inadvertent destruction of data, missing a key custodian, the risk of relying on time-intensive IT processes, and the risk of overblowing the budget with each new matter. There's a lot of risk. But what exactly is the litigation hold? Well, in short, a litigation hold arises from the duty to preserve information for pending or reasonably anticipated litigation. Every person that is covered by this obligation, as well as the organization, must not delete any of the data that the hold covers. Well, where exactly does the duty even come from? Well, if we hop into our DeLorean and head back to 2003, Judge Sarah Shinlin penned the now infamous Zubilay case, in which she said in part, once a party reasonably anticipates litigation, it must suspend its routine document retention destruction policy and put all the data on a litigation hold. Now, if we travel 7 years later, the equally infamous Pension Committee case said that the failure to issue a written litigation hold constitutes gross negligence, and that failure to preserve the data has led to more serious repercussions, or as I always like to say, omnia praesumptur contra spoliatorum. Now, there, I finally got to use Latin I learned in law school. What that basically means is that if a party knowingly or willingly destroys data that should have been preserved under litigation hold, the fact finder is allowed to draw an unfavorable inference against that spoliating party. But beyond just an adverse inference or sanctions, you could actually be liable to criminal penalties. Now, our friends over at the Sedona stated in Principle 5 of the Sedona Principles that preservation obligations requires reasonable and good faith efforts, and noted, just as equally, that it is unreasonable to expect parties to take every conceivable step to preserve potentially relevant data. Now, while good faith and reasonableness have always been the de facto standard, it is very elusive. Plus, it can be very challenging to ensure that you have the right wording to go into the whole document, have a visual understanding of the types of data, where it exists, secure an acknowledgement of that hold, and remind the custodians of their ongoing obligations. That's a lot. So, while we have a pretty fair understanding as to the why and the when, there's no mention anywhere of the how, or what mechanism in which we need to use to put a hold in place. As a result, ask a room of legal professionals, and I assure you, the vast number of them will say that they manage the hold process with a spreadsheet. So, forget about automation and compliance. It's fair to say that there are so many scenarios in which this sets a company up for unnecessary risk. Legal professionals I speak with say that they know that there's got to be a better way, but that better way needs to be, number one, cost effective, naturally, 2, easy to set up and manage, 3, doesn't take weeks of training just to understand how the software works, and 4, relieves IT from the risk of not putting a hold in place correctly. Now, we get that. We understand the challenges associated with the return on investment and loss of time involved in implementing new software. That's why at Catalyst, we have Insight Hold and Collect to automate the process of creating, sending, tracking legal holds, as well as collecting and preserving the data. By automating the legal hold process, you reduce the risk of sanctions for lost evidence, and most importantly, it gives you peace of mind. Insight Legal Hold and Collect is a cloud-based, SaaS-based application that provides an integrated centralized management platform for custodians and data. It automates time-intensive parts of the processes, including hold creation, key custodian identification, acknowledgement tracking, web-based employee interviews with the ability to create customizable questionnaires, and automatic reminders, and robust systems for hold tracking, escalations, and follow-up. Insight Hold and Collect connects to Active Directory, corporate HR systems such as Workday and SAP, and enterprise productivity and email applications such as O365 and Microsoft Exchange. Plus, the interface is simple and intuitive and can be learned with a minimum of training. What's more, it frees up IT departments to not have to worry about installing, upgrading, and managing the software. It has beautiful visual reporting and extensive audit tracking, so you can monitor actions taken from the beginning to the end of the hold process, which protects you when questions arise later. And, as icing on the cake, because we all love icing, once you're ready, Insight Hold and Collect is fully integrated with our Catalyst Insight Discovery platform, which allows for ease of preservation or promotion for review and minimizes errors transferring data between systems and vendors. Look, understanding when to impose a litigation hold and complying with that obligation and knowing when it ends can be tricky. Managing the litigation hold with spreadsheets or on paper makes it hard to resurrect the hold process, opening you up for later criticism and potential sanctions. So why chance it? Insight Hold and Collect is absolutely the most logical and reasonable approach on the market today. So, if you think you'd like to be more productive and successful by reducing your company's risk associated with the litigation hold lifecycle, let's talk. My contact information is in the post. And don't forget, if you like today's video, go ahead and hit that share button here on LinkedIn and be sure to use the hashtag eDiscoveryGoldNuggets. Until next time, I'm Daniel Gold. Thanks for watching.